One question we frequently get is, why do I need an operating agreement? Why would my business need an operating agreement? Well, the answer to that is we could tell you just an unlimited amount of horror stories of people that don't have operating agreements and what happens when you do not have an operating agreement. Hey there, this is attorney Sarah Holmes of Holmes Business Law P.C. We are a business and trademark law firm that also offers general counsel subscription services to business owners. Now, what is an operating agreement in the first place? Well, all right, if you have a business entity set up as an LLC, which is a limited liability company, the document that controls your business is an operating agreement. Now, if you have a single member owner, that operating agreement should really be more of a formality. It should be a very simplified document, maybe 2 to 3 pages is what we give people. And it simply outlines that this is a separate business, where it is set up, who the registered agent is, what is the equity, maybe some restrictions around admitting new members, and things like that. So for a single member, it can be a very simplified, streamlined document. Now, the real issue with operating agreements is when you have more than one member, i.e. business partners. In that instance, an operating agreement is like absolutely critical for your business. Why? All right, well, a couple reasons. One is that it's going to outline the equity of each owner. So meaning if Bob and I are in business together, that operating agreement should spell out that I own 50% and Bob owns 50%. That's number one. Number two would be it's going to outline the voting rights in that business, right? So if Bob and I are 50% owners, the question is, do our votes follow our equity? Meaning that either Bob and I can have one vote each, right? Bob and I could each vote according to our equity, which means I get a vote equivalent to 50%. He gets a vote equivalent to 50%, which is still basically a one-on-one. Equal voting power. Or can we say that Bob is really more of a silent investor, silent partner, and I'm the one running the business with all the power over voting? Okay, so if we do that, we could do something like appoint me as the manager of the business. I'm tasked with the day-to-day decisions. Maybe Bob comes in on major votes like mergers, acquisitions, selling the business, dissolving the business, things like that. So in an operating agreement, you can make things as complicated or uncomplicated as you and your business partner want. So the third reason in there would be to have provisions in terms of an exit. Like if either partner ever wants to exit the business, what would happen at that point? And it could be an exit for good reasons, or it could be an exit for unfortunate reasons, such as one of the business partners dies or becomes disabled. But again, it could also be simply, hey, I don't want to be in this business anymore. I'm going to move to a different state next week, right? So where partners start to run into trouble there is, number one, they don't agree as to what the other partner should be paid to get out of the business. And number two, they might not even agree in the first place as to whether they're willing to let the partner out of the business. So in an operating agreement, we can control all of those variables and actually have formulas for a buyout, or we can say in there who you go to in the event of a buyout, and that could all be outlined in there and have it be preset so that if several years down the road, Bob and I get into a disagreement and we stop communicating and we have a problem being business partners, we can pull out our operating agreement and see how we are supposed to get out of it. Now, some people do not have this document, and so when they get into a partnership dispute, the biggest problem they have is that they have to go along with the state's default rules governing LLCs. And unfortunately, what they find is often those state rules are not in their favor. For example, in Pennsylvania, the statutes might say that all business decisions have to be unanimous. So if you had, in that scenario, 3 partners, if it's Bob, myself, and Jim are all business partners, and we're all 33.33%, and normally Jim and I could team up and maybe vote Bob out of the business and buy him out. If we don't have an operating agreement and the state's default rules say that our votes have to be unanimous, we can't get anybody out of that business ever. We all would have to agree on that. And if we're already in a dispute and already in a disagreement, clearly that's not something that is going to happen. The operating agreement can also spell out what does happen in the event of a dispute. It might have some mediation provisions that say that the parties would go to a friendly mediation if they run into a dispute. It might say that ultimately, if they can't get past their disagreements, they might go to arbitration and hire an arbitrator to decide on the dispute. Like, what you don't really want to do is wind up in court with business partners, because you might be disappointed as to what the court decides is best for your business, or the court might decide that they're not going to substitute their judgment for yours, and your business is going to, be stuck and not in a good place. So not good outcomes. That's why a critical document to have in your business, especially with partners, is that operating agreement. So we have actually a process that we walk business partners through for operating agreements. If you need help with that, you can feel free to reach out to our office. Our number is 215-482-0285. Thanks.